先生、女士们，我们
Ladies and gentlemen, the event will commence soon. Please be seated.
please take a seat. Thank you.
Ladies and gentlemen, welcome to Gateway to the Opportunities in the GBA, co-educated by DOJ and other organizations. First of all, big round of applause to everyone here. Thank you so much. I'm the MC today, Yuki. Before we start the event today, let's have Mr. Chen Kwon, SBSJP, and also Tian Xin, Director of the Bureau of Lawyers' Work of the Ministry of Justice. Mr. Cheng Xudong, Director General, Department of Justice of Guangdong Province. Ms. Lun Wen-ying Coco, Director of the Legal Affairs Bureau of the Government of the Macau SAR. Please come to the stage for a group photo. Thank you. Okay, please stay on the stage. Now let's welcome Ms. Tang Huizhu, member of the Basic Law Committee of Hong Kong. Mr. Luo Jianhua, Director of the Department of Justice of Anhui Province. Mr. Chen Junshen, Chairman of China Legal Services Hong Kong Limited. Mr. Chen Zeming, President of the Law Society of Hong Kong. And Mr. Li Haoran, member of the Basic Law Committee of the Standing Committee of the MPC, to the stage for a photo. Thank you so much for coming. Thank you. So, Mr. Chan, please stay on the stage. Other guests, please return to your seats. Thank you. And now let's invite Mr. Chen Kwan, Deputy Secretary for Justice, Hong Kong Sa Region of the People's Republic of China. Let's welcome DSS. Distinguished Mr. Tianxin, Mr. Luo, Mr. Liang, dear guests, good morning. Welcome to today's event themed around GBA session, and I look forward to our exchanges and communications today to push GBA's legal practices forward. GBA is a frontrunner for opening up and reform, and it's very important in modernization, has a very important role. The population is around 19 million. The economy exceeded 1.3 trillion RMB. It played a very important role in opening up and going global, and also played an important role in dual circulation in China. President Xi Jinping also emphasizes that we must push forward the construction of GBA to make GBA a strategic role, a pilot and example for development. GBA needs to realize a high-level opening up and globalization to build a legalized business environment to push the development of the GBA more sustainably. GBA enjoys one country, two system, three regions. It is unprecedented in the whole world. So three regions in this GBA can provide a very leading role in productivity, people exchanges, etc. Of course, there are a lot of challenges. In order to tackle these, we need to tap into or leverage on each other to provide stronghold for each region within GBA. Later, our DOJ colleague and also Mr. Tianxin will have a keynote speech and will introduce what we have launched in September. That is our 3-year testing regime in GBA. State Council issued a revised document for law practitioners in Hong Kong and Macau to practice in mainland China. And we have already achieved a lot of support from mainland China companies. And it become much more implemented with these decisions going forward. So for Hong Kong and Macau's legal practitioners, we can sign up for the test in mainland China, and the duration has been shortened from 5 years to 3 years. So after passing the test, actually they are very constructive leaders in solving disputes in this region. They can share their expertise and experiences with other professionals. So for law practitioners in Hong Kong, we can provide common law perspective and provide international dispute resolution solutions. And GBA can provide protection for companies going global. We can provide one-stop services. This year, for Hong Kong, Macau, and other cities in GBA, we held a lot of events and workshops this year. We hope we can provide a platform for exchanges and provide each party in this region to give full play to the synergies and give full play to our legal capabilities in GBA. I believe with GBA's testing mechanism being more well-fledged, our legal experts will improve their quality to better serve the companies within GBA and also overseas companies. I, together with our law society here in Hong Kong, want to thank our governments and also Department of Justice. Thank you so much for facilitating the communication between Hong Kong lawyers and mainland China lawyers to push our GBA's quality and to provide a better legal environment and to align all the legal systems within the region. And I believe these three areas, on top of what we have now, we will continue to optimize, improve the systems. Today, we also have mock court today session. We hope through this mock sessions in civil cases, we can have a better understanding of the ways and also the differences among these three regions, how we tackle these cases. And we hope through today's session, you can have a better understanding and at least got a feeling to explore together how to have better ways to solve disputes and can provoke thinking and also to deepen the understanding and exchanges. DOJ is actively trying to implement policies that can help address cross-border disputes, including building commerce resolution or other ways. For example, arbitration or mediation in Hong Kong. We have already offered the services to companies registered in Qianhai, Shenzhen. They can have more flexibility and discretion to choose Hong Kong law as their contract law. So if you come here in Hong Kong for arbitration or mediation, it won't affect. It has more flexibility. So the agreements that signed here in Hong Kong will also be more enforceable and powerful. It can attract more companies to come to GBA. Other than that, mediation actually caters to China's philosophy. That is, we put peace at the first place. It is also cost-effective to solve cross-border disputes. And thus, DOJ is committed to further promote in GBA using more mediation or arbitration. In past years, with the concerted efforts of the legal departments in GBA region, we have improved code of ethics and guidelines to serve as a leading guiding principle within this region. And last year, we improved the policy and to let all the organizers and also mediators within the region to actively learn these policies. With these policies in place, it will encourage individuals and companies within the region to take mediation or arbitration to solve disputes. And we also would like to encourage online court or online mediation and also to improve the cross-border dispute resolution's efficiency, reduce cost. So we also give importance to young people. We believe young people is vital to the country's development. Actually, GBA offers huge potential for young people. This afternoon, we are going to talk about GBA opportunities, building a future GBA for young lawyers. And we hope through that it will provide a platform for young lawyers to exchange their experiences when practicing in GBA. The forum will first invite experts from commercial, legal aspects, and we will talk about
the following communications later. We're going to have question and answer sessions to enclose the vast opportunities provided within this region. And also from the Hong Kong Law Society and some of the young representatives in this specific law area, and also 3 law academies. There are a group of students. They explore the cities in the Greater Bay Area, which means and represents that we highly encourage the young people to experience more in this region so that the 3 regions can cooperate and help each other in order to provide a better development within GBA. We have actually experienced and explored different multiple cities in mainland China in order to improve the communication. Everyone, this year we have set up the community in order to prove and promote the legal services and help within the GBA, making sure that we can all contribute to development of the GBA. I sincerely hope that we can communicate further, deepen our discussions, and cooperate together to contribute our insights and expertise in this area. And last, I would like to thank everyone for presenting here, for your kind support. Thank you. Please be seated. Thank you. Now, let's invite Mr. Chen Xudong for the opening speech. Let's welcome Mr. Chen. He's the Director General of the Department of Justice of Guangdong Province. Dear guests, dear Tian, Mr. Tian, and friends, guests, everyone, good morning. I'm pleased and honored to participate in this special legal week. And for this, we have this specific theme: Bay Area cooperation for mutual benefit and win-win. I believe that this can further promote the cooperation between the 3 places within the region. And this would definitely help a lot in promoting the further cooperation and the high development of this region. On behalf of my department, I'd like to show my support and wish for the development of this place. I'd like to express my heartfelt thanks for all the legal practitioners within this region. The Greater Bay Area policy is a vital national policy with the development of hard connectivity of infrastructure in this region. The 1-hour living circle in the Bay Area has basically taken shape. More and more people from Hong Kong and Macau are integrating into the construction of the GBA, showing that the three places of Guangdong, Hong Kong, and Macau have joined discussions and joint efforts. In the meantime, we have the soft connection between the three places, especially in the legal area. The departments within this region focused on cooperating with each other together, making sure that we can have the better cooperation using the legal services window in order to make sure that we achieve a series of fruitful results. We worked together to build a mechanism. In recent years, the legal departments of the three governments have successfully established working mechanisms, such as the joint meeting of the legal department of the GBA, the joint meeting of the Lawyer Association of the GBA, etc. And every year we're going to have regular annual meeting. Even during the COVID period, we didn't stop. We have communicated further within this region to set up a test region, making sure that we have the reform of the partnership and joint venture law firm mechanism, the coordination of mediation work standards in the Greater Bay Area, and the cross-border collaboration of arbitration services. The legal cooperation in the Greater Bay Area continuously stimulate new momentum. So it's a step-by-step, case-by-case improvement. So the legal cooperation is further developed. We carefully plan and build a platform, building Qianhai, Shenzhen, Hong Kong International Legal District, Qin'ao International Legal Cluster District, and Nansha International Area, Guangzhou Central Legal District have been constructed to high standards, and a series of supporting policies and measures have been introduced and implemented to attract hatches of legal service personnel and institutions from Hong Kong and Macau to Guangdong. We will promote the establishment of a branch of Shenzhen Court of International Arbitration in Hong Kong, strengthen exchanges and joint training of legal talents in the three places, and actively create a vivid situation of you among us and you among me in the legal services of the three places, and the rule of law cooperation in the Greater Bay Area keeps showing new trends. Especially since this year, the legal departments and associations of the three governments have actively carried out offline visits and interactions and reached a number of consensuses on further deepening legal cooperation in the Greater Bay Area with everyone's joint efforts. The Shenzhen-Hong Kong Legal Cooperation Agreement was successfully signed, and joint activities such as the Bay Area Statement Legal Seminar and Hong Kong and Macau Legal Lectures were successfully held. Legal department personnel of the three governments of the Guangdong, Hong Kong, Macau, Greater Bay Area were present in Macau. To name a few, these are only a few of the activities. These achievements cannot be achieved without the strong leadership of General Secretary Mr. Xi and the Party Central Committee, the full cooperation of the legal departments of the government of Guangdong. They have provided us very detailed guidance in this area, and the hard work this cannot be achieved without the hard work of the legal professionals in this region. This year, in April, General Secretary Xi inspected Guangdong, and he emphasized that Guangdong Greater Bay Area should be built into a strategic fulcrum for the new development pattern, a demonstration site for high-quality development, and a leading place for Chinese-style modernization. In September, the state Council issued the Shenzhen Park development, and we need to build further this GBA. In October, General Secretary Xi delivered a keynote speech at the opening ceremony of the third Belt and Road International Cooperation Summit Forum. He announced China's 8 actions to support high-quality joint construction of the Belt and Road and emphasized that only through win-win cooperation can we get things done, do good things, and do great things. All these points point the way forward for us to further strengthen legal cooperation between GBA and better serve the overall development of the country. Facing a new situation, new tasks, and new requirements, we must build on existing achievements and rely on the hard connectivity of the Greater Bay Area infrastructure to deepen the soft connectivity of the rules and mechanisms of the region. Mr. Xi has already expressed his charming wishes for this region and focus on it to make it a realization, make it a real. I have 3 following suggestions. The first is to work in the same direction in the Bay Area. The reason that we're so passionate in cooperating together is because that we are all in the same direction and we have continued to enthusiastic and fruitful cooperated with each other because we are all move forward in the direction of sharing new opportunities in the development of the Bay Area and jointly promoting new results in the development of the Bay Area. The future direction will be still focused on 1.2 places this policy and under the central government's policy guidance. To stick with the one country, two system policy and promote Hong Kong and Macau to better integrate into the overall development of the country, contributing Bay Area power to promote Chinese-style modernization. I believe that as long as we unswervingly move forward in this direction and work together, the legal cooperation in the GBA will achieve even much more better. The second suggestion is to achieve mutual benefit and win-win results while seeking common ground while resolving differences. We have multiple differences, but just because of these differences, we can benefit each other and we have further room to make it better. These 3 places are originated from the same region and connected by mountains, rivers, have close humanities and share the same culture. Practice has proved that as long as we adhere to the foundation of one country, one policy, that we can make sure that we can have a better cooperation. I very much look forward to everyone being able to build consensus and create sparks in every exchange event, and looking forward to use innovative methods to strengthen the legal personnel from the 3 places to promote the rule of law construction in GBA. My third suggestion is to seize the opportunity in major strategies. As the construction of GBA enters a new stage, the legal cooperation in GBA has also entered a new stage, facing the urgent requirement to move to a deeper and higher level. This requires us to make good use of major cooperation platforms such as Nansha, Hengqin, etc. We have such policy as guidance, and we have different emphasizes within that when we have test fuse. So under the different guidances, we would like to continue the cooperation.
We'd like to deepen the legal services such as lawyer, mediation, arbitration, notarization, and we would strive to build the best legal services Bay Area. We should establish a cultivation of legal talents mechanism in Guangdong, Hong Kong, and Macau, and create a highland of legal talents. At the same time, we should promote the expansion of legal cooperation in these three areas, from the field of legal services to legislation, law enforcement, etc. I'd like to have the diversified forms of realization, such as one matter, three places, one policy, three places, one regulation, three places, to inject a continuous surge of power into the high quality development of the GBA through high level rule of law. The Guangdong Provincial Department of Justice will continue to adhere to the principles of central government, and we'd like to cater and also meet the needs of Hong Kong, Macau, and Guangdong, together with DOJ in Hong Kong and Legal Area Bureau of Macau. We will enhance mutual trust through cooperation, promote development through cooperation, and share achievements through cooperation. We'll continuously consolidate the new consensus and create a new chapter in exchange and cooperation. Finally, I wish this event a complete success, and I wish all of the participants today, I wish you good health and smooth life. Thank you so much, and welcome you to Guangdong if you have some time. Thank you. Please be seated, Mr. Chen. Now, let's invite Ms. Coco Learn. She's the director of the Legal Areas Affairs Bureau of Macau SAR. Welcome, Ms. Learn. Dear DSJ Mr. Chen, Director General Chen, distinguished guests, experts, scholars, and colleagues, good morning. I'm delighted to participate in today's Hong Kong Legal Week event with all of you. Today marks the fourth day of the Legal Week, and the theme of today is Gateway to the Opportunities in GBA. I believe it's a significant occasion for legal professionals from Guangdong, Hong Kong, and Macau to offer suggestions and contribute to the high-quality development of GBA. It is very meaningful. The GBA region is a new practice in the development of the one country, two systems framework, and a new attempt by the country to promote a comprehensive pattern of opening up. It is conducive to integrating Hong Kong and Macau into the overall national development. Over the past 4 years, the construction of GBA has achieved remarkable results and continuously enhanced its comprehensive strengths. It has become one of the most open and economically vibrant regions in China. Currently, Macau government has seized the opportunity, and following the development of one center, one platform, one base, according to the previously announced Economic Diversification Plan of Macau 2024 to 2028, we are trying to promote a strategy of 1+4, deepening the tourism and leisure industry, promoting healthcare, modern finance, high-tech, convention, trade, culture, and sports as our key industries. The establishment of the Heqing Guangdong-Macau In-Depth Cooperation Zone is a new measure by the central government to support the economic diversification of Macau. It's also an important strategic point in the overall planning of the GBA. Strengthening the rule of law in the GBA is a demand of the times for promoting the modernization of GBA. Macau SAR government has been promoting the three regions to leverage their respective advantages, promoting the convergence of rules, mechanisms, and talent cultivation, enhancing legal exchanges and cooperation. First, on exploring rules alignment, I think it means soft connection Over the past 4 years, the Macau SAR government has collaborated with legal departments in mainland China and Hong Kong to achieve innovative breakthroughs. For these three areas, we are trying to issue criteria for the qualification and evaluation of GBA mediators. At the same time, in terms of soft connectivity in Hong Kong and Macau, we have realized Hong Kong and Macau legal professionals in the fields of tourism, architecture, engineering, healthcare, pharmaceutical tech, etc., to provide services across the board. The experiences gained hold significant reference value in GBA. Second is deepen mechanisms alignment. The Macau SAR government has collaborated with mainland judicial departments over the years to strengthen judicial and arbitration cooperation. Multiple agreements have been signed to provide legal services to better promote or protect the legal rights of clients. And we would like to implement a new mechanism of joint discussion, construction, management, and sharing. We'd like to have a law that is in line with international standards. This poses higher requirements for rules and mechanism alignment between the two regions, but also provides broader space and a better platform for their integrated development. Earlier this year, GBA Henqing Cooperation Zones Regulation on Development was issued. It specified the governance system, planning, and construction for the cooperation region. It highlights support for more relaxed people exchange policies, preferential standards for corporate and individual income tax, the establishment of a highly convenient market access system, and the facilitation of free and convenient flow of funds between the region. And we would like to jointly promote the formulation of a series of law and regulation, accelerate the integrated development of Henqing and Macau. Third is on strengthening talent cultivation. We cannot achieve great things without talents. Macau SAR government promotes the two-way cultivation mechanism for legal talents, aiming to create a new highland for legal services in the GBA. Last year, during the fourth joint meeting of legal departments of Guangdong, Hong Kong, and Macau, a proposal was approved to organize training courses for personnel in legal departments of the Greater Bay Area. This September, the first training course was successfully held in Macau. Through the training, legal professionals from the three regions deepened their understanding of the legal system in Macau, and also it enhanced exchanges and cooperation among the legal professionals, making the soft connectivity work between the three regions more smooth. Furthermore, Macau, as a Portuguese-speaking region, going forward, we would like to leverage our advantages of legal system to further expand economic and trade markets with Portuguese-speaking countries. We would like to serve Portuguese-speaking jurisdictions. Ladies and gentlemen, distinguished guests, and fellow legal professionals, the construction of GBA injects new vitality into the integration of Hong Kong and Macau. It is also a strategic deployment for the country to deepen its opening up and promote high-quality development. It requires the joint efforts of all parties involved. The Legal Week here provides an excellent platform for exchange and cooperation among legal practitioners from the three regions. Look forward to hearing from experts and scholars. And I wish this Legal Week event a complete success and wish all of the guests, scholars, a happy and fulfilling life. Thank you so much. Thank you, Coco Lum. Please be seated. Now, let's give Mr. Zhang, Mr. Chen and Ms. Le, thank you for your remarks. Now, let's welcome Director of the Bureau of Lawyers' Work of the Ministry of Justice, Mr. Tian Xing, to give us a keynote speech. Welcome. Distinguished Mr. Chen, and also Ms. Lun, dear guests, ladies and gentlemen, friends, good morning. Very happy to be here at Hong Kong Legal Week 2023. Today, the theme is to explore opportunities in GBA. HK Legal Week is hosted by Department of Justice Hong Kong. Since 2019, its first event, this year marks the 4th year. And in promoting legal exchanges, it played a very important role. This legal week themed GBA opportunities, and we carried breakout sessions later. We would like to explore the theory and practice of GBA legal services. It actually played a very important role to the overall development of Greater Bay Area. As you may know, the central government attaches great importance to Hong Kong and Macau's development. We care Hong Kong and Macau's people's life and well-being. We'd like to see the governments to develop the well-being of Hong Kong and Macau. President Xi strengthened a lot of times that we'd like to give full play to Hong Kong and Macau's special characteristics. We'd like to promote the exchange between Macau and Hong Kong for win-win cooperation. We like to build the world-class city cluster and a Bay Area. In April this year, when President Xi was visiting GBA, he pointed out that under the new Economic Development Forum, GBA played an important role. GBA emphasizes to establish us as a strategic focal point for development. It will be a leading place that signifies China's modern development. It shows central government's priority on developing GBA. And under this new era, to better integrating Macau and Hong Kong into national development, it is a very important guarantee. We'd like to promote legal professionals in Hong Kong and Macau to come to mainland China. It is also a very important initiative. Today's event, I'd like to analyze from these 3 points. First is Hong Kong and Macau's legal professionals to practice law in mainland China in order to promote GBA and also to give opportunities to lawyers from Hong Kong and Macau. In August 2020, the MPC decided to authorize State Council to allow Hong Kong and Macau legal professionals to practice law and also attain legal qualifications in the 9 cities in GBA. Same period, State Council printed the pilot plan and give very detailed plan for the testing mechanism.
Have set up strict, detailed rules in these areas, and we have set up laws on the experts guiding them how to practice laws in the mainland China. This is the very critical step, making sure everyone is obeying the rules and reviewing central government's prioritizing in this particular area, making sure that GBA is enclosed in the whole development with other mainland cities in mainland China. Not only do we have the advantages of our special region location and also the identification, and we promote and encourage the legal practitioners to have dual certificates in both mainland China and also Hong Kong and Macau regions, so that the expertise can practice law in mainland China. This also reviews the urgent needs for the local expertise to expand business into mainland China. During the process of practicing law in mainland China for the Hong Kong and Macau lawyers, they will enjoy the same rights, and their rights will be also protected by the mainland China's laws if they have the relevant professional certificate, so that they can better communicate with their colleagues within this industry, with other lawyers from the mainland China. The Justice Department focuses making sure that it practicing and operates under the guidance of the central government's policy, making sure that we'll make sure the tests will be operated smoothly, and different departments can cooperate further and better in order to make sure we offer the professional certificate for the law practitioners, providing great opportunities for the Greater Bay Area. We have already achieved some results. We have organized the third tests for all the Hong Kong and Macau lawyers participating in this test, among which 360 lawyers from Hong Kong and Macau have received a certificate issued by the mainland China. They have already being familiar with the law system from the international laws as well as the mainland China's law, so that they can contribute in the civil cases and better quality team building for the Greater Bay Area. The second aspect I'd like to mention is the test area for the Greater Bay Area. Hong Kong, Macau lawyers would like to participate in this test field in the Greater Bay Area. So this process will be prolonged. In this year, on January the 1st, we have already passed the decision from the central government that we would encourage the law practitioners from Hong Kong and Macau lawyers to have the certificates offered and issued from the mainland China. We have make sure this can be processed. The state has actually issued the modifications of this specific details, making sure that towards the end of September, this can be pushed as planned. Some of the requirements, for example, that you have to accumulate more than 5 years of practicing law experience, has made a change into 3 years experience. which help further benefit the local lawyers to have the certificate. We have 3 benefits. First, that it will review the test and the critical role GBA is playing in this region. GBA's law practitioners playing a practical role connecting both mainland China and the GBA, contributing high-quality legal services within the region. At the same time, upon requirements or needs, we need to improve further on the efficiency and the results. We have assigned that this test field program will be prolonged for another 3 years, making sure that we set up a good platform for the Hong Kong and Macau lawyers to be enclosed within the China legal system. The young people are the future of the country. During the process, the Justice Department, together with along with other departments, we have used the interview and meetings, consulting their ideas and opinions of the legal practitioners about their ideas, how they view about the program, the GBA program, listening to their voices, for example, their ideas and opinions about details of passing the tests, so we can further understanding their needs, making sure they all contribute to the building of the GBA. The third will be pay attention to the policies made. This is actually a test for the China to see how should we progress in this region. Some of the departments, for example, Guangdong province and also the law practitioner organizations have provided their own opinions in this issue regarding how to connect better for the 2 legal systems. This shall all be tested and studied. Prolonging the testing period will help us to better understand the local specialties, building up a good platform for future development. The decision of prolonging this program has received a round of applause from the law practitioners. They welcome this decision. Another part is we would help the legal professionals to play a better role in GBA as well as mainland China. China is focusing on further modernization. We have committed to support the Greater Bay Area, its development, promoting its further development, supporting Hong Kong and Macau to implement themselves into the greater whole development of China, contributing creating more opportunities for the various cooperation between Hong Kong, Macau, and mainland China. The next step is we should consider how to further promote the developments of GBA and also in law area. In most recent years, under the guidance of Mr. Xi, we have witnessed some of the significant changes in different areas, as well as in legal practices. we have achieved significant progress in different various areas. We would like to further deepen our progress, further develop our mechanisms and systems to develop a better infrastructure for mainland China. And the future of the Hong Kong and Macau legal practitioners is very bright in mainland China. We'll set different mechanisms to support and make sure they would have the opportunities to practice law in mainland China, positively encourage contributing China a better country. Second point is also they can play a better role in promoting GBA's development. After the policy is issued, we have witnessed great progress in GBA, Hengqin, Qianhai, Nansha, etc. These platforms are further developed. International technology is also progressing. The modern development can be seen. Connecting different systems and mechanisms can be also observed. The Hong Kong and Macau's common people's lives are further improved within the region. Hong Kong and Macau further cooperate in commercial, education, in commerce, education, and trade, as well as providing more opportunities for the law practitioners in mainland China. We like to push and make sure that we have detailed, specific regulations and rules in order to support and help the legal experts to practice in mainland China, leverage their expertise, contributing with their expertise, and make development even faster. Third, they will help to communicate better domestic and also globally. We're going to have various platforms and even deepen cooperation between mainland China and Hong Kong and Macau. We have conducted multiple activities and events in order to promote the further cooperation for the law practitioners in the region, deepen our understanding of each other, benefit each other, and working together to make GBA a more competitive region. We will continue our contribution, and we have already seen significant improvements and results. I hope that with the help and support from the central government, this test point region program can be further developed, that we can have some fruitful and solid results afterwards. And I also hope that our young legal practitioners can participate in this development, contributing their talents into making the country a better country. Last, I wish the program a big success. Thank you.
So the following session is forum and also mock court. If you have any question, you can use your mobile phone to scan the QR code, or through the online link. You can input your question there. For online participants, please input your question to the chat box, and we will answer your question during Q&A session. Today, we're so happy to have Mr. Stephen Wang as our moderator. Welcome, Mr. Wang. Our speakers are Mr. Edward Liu, MH, Mr. Lawson Chen, and Dr. Li Ke. Big round of applause for them. Mr. Stephen Wong is a PRC lawyer, GBA expert for proof of foreign law appointed by the Guangdong Higher People's Court. So now, floor is yours, Mr. Wong. Thank you, MC. My title are all for Mandarin. And dear guests, legal professionals, welcome all of you to today's session. My name is Stephen Wang. Today, our topic today is advancing the legal practice in the GBA. So legal practice in GBA can be achieved without the concerted efforts of three parties. And we are very happy to have three distinguished speakers. First, we have Dr. Li Ke, Program Coordinator and Senior Instructor of Bachelor of Law in Chinese Law and Global Lecture, University of Macau. Mr. Lawson Chen, Vice President, Guangdong Lawyers Association, and our Hong Kong rep, Mr. Edward Liu, Partner, Highwind and Partners LLP. So first of all, three speakers will give them their speech, and the second session, perhaps we may not have time, but we will try to have a Q&A session. So without further ado, let's welcome Mr. Edward Liu as our Hong Kong representative. His speech will be focuses on helping legal practices in GBA. Thank you. Thank you so much, Mr. Wang, and thank you, DOJ, for invitation. I'm very thrilled to be here. My speech just now already mentioned, it's more from a Hong Kong perspective to see how to help the development within the GBA and also to promote the overseas legal practice. Mr. Chen just reviewed for GBA legal testing accreditation, the development. When I was listening, I checked my data and I found my data is correct because I was playing safe. I said exceeding something something. So first of all, my topic, Hong Kong and Macau lawyers going to GBA. What is a route? For me, I think it can be divided into four parts. Our country is deepening its opening up and reform. Mainland China is establishing the free trade zone, Belt and Road Initiative, and GBA construction. These four sectors, they all engage cross-border trade, cross-border dispute resolution as their basis. So Hong Kong and Macau lawyers are having more opportunities to integrate into mainland China's development. That's my personal understanding. Like we can enter GBA, rely on GBA to improve our capabilities. So for Hong Kong and Macau lawyers, it has actually since 1997, Hong Kong's returning back to mainland China. We have been working on this since then. And also after Macau's handover to mainland China in 1999, we also did some work covering Macau. So I'd like to review the timeline. Each year we have our work, but the first year or the most important document signaling Hong Kong and Macau, it's actually called CEPA, the Mainland and Hong Kong Closer Economic Partnership Arrangement. It allows Hong Kong barristers to become or act as agents in civil litigation in mainland China in their capacity as citizens. So the barristers in Hong Kong could go to mainland China, opened a large window. After decades of efforts, in 2014, we actually have the trial measure for the implementation of partnership association between Hong Kong and Macau law firms and mainland China law firms in Guangdong province. In 2018, just now, the Guangdong minister, Dr. Chen, mentioned Hong Kong and Macau and the Lawyer Association of the 9 cities in the Pearl River Delta confirmed the establishment of a joint conference system of lawyers association in Guangdong, Hong Kong, Macau. Just now, Mr. Tian introduced since 2018, Hong Kong and Macau lawyers can leverage on GBA platform to enter to mainland China. When we investigated into the lawyer test, I was engaged in the investigation, and then I saw our central government's effort to integrate Hong Kong and Macau's lawyers. They did a lot of work. So we adopted this GBA testing mechanism to allow Hong Kong and Macau lawyers have direct ways to serve mainland China companies. Just now, you may have heard, since July 2023, in Shenzhen, there are more than 40 firms that accepted 150 legal professionals. So Shenzhen accounts for the whole GBA region, around half of the legal professionals. In the past years, you can see 1,500 lawyers attended the GBA law test, and over 300 lawyers were accredited. And let's see, from Hong Kong perspective, how can we engage into our GBA initiative? I won't go through them one by one. For example, the common law system in Hong Kong, and also we are close to mainland China. We are a melting pot in Asia. So these are what we know. And we have over 11,000 solicitors, over 1,500 barristers, over 1,400 registered foreign lawyers. I'd like to distinguish 2 points. One is registered foreign lawyers and registered foreign firms. I can feel the vibrant and diversity here in the city. As long as you want to find a law firm that's specific in the jurisdiction, you can always find one. Last time, my colleague would like to find a lawyer from Luxembourg. We found one. I didn't even know. That was the first time I know we could also have Luxembourg law firm. So we can see Hong Kong's legal platform can provide one-stop service to the network in GBA. And now, according to the SAR government's policy address, I have several thoughts. First, I think we could establish a cross-border legal advisory service platform, provide training workshops to tap into technology, etc. These are all used to strengthen exchange. I think exchange is really critical. GBA actually is a platform for exchange and communication. After we know each other, and with the mutual understanding, can we promote collaboration? On the other hand, to build a platform, it actually requires the efforts from 3 parties. I think we can establish cross-border collaboration among law schools, etc. Yeah, once again, it's more about cooperation, exchange, and communication. I'd like to say it one more time. As Mr. Zhen mentioned earlier, about the cross-border settlement platform. I'm very happy to be a member of it and joined throughout the process in terms of the discussion. And I look forward, after all the policies being launched, the mediation services in GBA could be world leading. And Hong Kong indeed has its unique competitive edge in mediation. If you were here yesterday, you must have heard thoughts and experiences from top mediators. I think Hong Kong could provide a lot of contributions to the GBA mediation development. And just now mentioned Hong Kong capital, Hong Kong mediation. I won't emphasize once again, but I want to mention one thing. A lot of times when I attend activities, some mainland China mediation or lawyers, they are confused. They're saying, "Oh, aren't you coming to here to take away the market share? If the market opportunities are grabbed by Hong Kong lawyers, does it mean like we will have smaller portion of market share?" However, I think the most important thing is to build a world-class business environment. We all know Hong Kong is a natural free port that is world recognized. So working and living here in Hong Kong for several years, me personally, I think you need to provide the market with more opportunities and freedom. That is the most important thing. I think if, for example, a company in Shenzhen Qianhai registered there, shall it choose the mediation in mainland China or come to Hong Kong? We will leave the decision to the market. It is mutually beneficial, actually. If in the end, the Hong Kong companies choose to operate in Shenzhen, it means they recognize the business environment in Shenzhen. They recognize the legal services and arbitration system in Shenzhen. So once the trust is being built, they will choose Shenzhen. And on the other hand, it's the same. The Hong Kong arbitration system will improve in order to catch up to other capabilities. It's actually mutually beneficial. We can improve after referencing each other. And of course, foreign parties sometimes they may want to come back to common law here in Hong Kong. It's also fine if they hope that the whole legal set of legal system or the international arbitration alignment and international standard, Hong Kong may do a better job in this regard. So all in all, I'd like to see GBA. It can help improve the nation's cross-border legal service. We need to unite together and improve together. That's all about my sharing. Thank you so much. Thank you.
Thank you very much for Mr. Liu's wonderful speech. Let's invite our Mrs. Chen Fang, for the speech to cooperate, making sure that we can cooperate better. Let's invite. Ladies and gentlemen, dear guests and leaders, all the colleagues and law practitioners, good morning. It's such a pleasure that we can meet here on our legal week in Hong Kong so that we can discuss further the opportunities of GBA, how we can cooperate with each other and further contribute the further cooperation within the region. GBA has very special, unique policies and regions. One country, two policies, and its uniqueness is significant. We will pilot this area to have some innovative methods to further stimulate the cooperations within the region. I will discuss what kind of opportunities GBA is providing to the region and how to set up a better cooperation, etc. To discuss the topic. There will be 4 parts. I hope that it will be providing some of the feelings or ideas for all of you. The GDP participates 11% among in the whole China. Setting as the international hub globally, the GBA is contributing itself to the world. That has different factors. For the law practitioners, however, we, under such background, enjoy much more opportunities. And at the same time, this also requires us to further leverage our specialties and service qualities. Our guests also wish us to have various backgrounds with deep knowledge, providing one-stop legal services, and they also hope that they can solve disputes via mediation or arbitrations. So within the 3 regions, we have higher standards or requirements because of these uniquenesses. We need to pay high attention to these areas like internet and technology. In various areas, we can also cooperate. In GBA, the law experts can further communicate, share opinions and practices, experiences with each other, contributing to solve further disputes within the region. Our practitioners can further improve their expertise and skill sets in order to participate in this great development. We believe that we need to set up and build a good platform, providing good platform so that all the parties can search efficiently the information on the platform, encourage different parties to join the international issues, being able to solve disputes via mediations and arbitrations using technologies and other developments to contribute for the development of the region, to proactively educate the audience and the public the relevant knowledge, building their trust in the region on the quality of the legal services, and also provide some of the opportunities for the public to join together in the legal activities within the region, contribute together. I like to discuss further about the mediation part. We all know that recent years we have seen or witnessed great progress in mediation services. I highly recommend everyone to pay attention in this area because this is in line with our culture's harmonious development at this point. So this may contribute a significant role in solving international disputes. This can help the 3 places to cooperate together in solving international disputes. And during the process, we will deepen our understanding of various cultures and the systems, understanding of the systems, so that we can put aside our differences and unanimous, but focus on how we can cooperate better. We can use or practice the legal services under the guidances and the rules within the region. We set certain specific requirements and standards for the law experts to help them to better practice within the region. And we have provided a solid platform and supporting mechanisms for the talents to promote their businesses within the region. We focus also not only offline but online as well, providing further support for everyone on how to promote better the platform. We believe that we need to focus better in the legislation, regulations, and also the mechanisms building. Not only shall we deepen our cooperation in legislation discussion, cooperation, and innovative methods to solve disputes. With these bear insight, so that we can set up a better platform, sharing different insights, communicating better within the region. Such systems, the system is issued and the results can be guaranteed. On behalf of, I believe that the 3 places from different law societies, we all participate in this further development. And with the unique benefits, advantages of the 3 places, I believe we can further push forward the building more detailed and systematic mechanisms for the region. These are my sharings. Thank you. Thank you very much, Mr. Shen. You have actually shown us the bright future. So everyone, please do not be afraid of them charging by hours, so they can use their time very efficiently. Let's welcome Dr. Li Ke from Macau on her wonderful speech on how to promote further in the GBA. Welcome. Thank you very much, moderator. I'm very delighted to be here. And today, I'd like to discuss the soft connectivity of local services among the 3 regions, enhancing the cultivation of legal talents in the Greater Bay Area. And as previously mentioned, today, this year is the first, the 10th year, the 20th year of the further cooperation, and we are encouraging the Macau and Hong Kong law practitioners to practice laws in mainland China as well. And we were permitted to practice laws after passing the examinations, which was permitted by our state's policy. So some of my friends or my colleagues, they have already acquired such certificate, or some other of my friends are preparing actively to pass examinations so that they can provide their specialties and knowledge in practicing laws in the region. And this year, with the further deepened cooperation and development, this year we have further regulations setting a detailed guidelines and rules for the legal firms to cooperate and even set up offices in Hengqin. And if the offices successfully set up, they can earn a maximum of 2 million RMB for successfully setting up their offices in Hengqin. So we can see from these cases that not only we can see from the policies, but also from the different activities and promotions, we understand the great priority the country has set in developing GBA a better place, with a common goal that is to promote the economy in GBA. We have different pilot programs since last year. We have regulated in this guidance that we need to make sure that Macau is further connected with international legal environment, and we have actually different tests and trials in this area. Like, for example, in February, our legal societies were trying to one question, two answers for this solving the different disputes within these three places. Later, we're going to have a mock court, which is also a brilliant example for us to witness or see further how the legal services are practiced in the region. Not only we can understand or discuss, and also discuss in the regulations and rules, but also we understand further with the how to develop the GBA under the guidance of one country, two policies. So multiple speakers previously have already mentioned some of the methods or guidance or rules that have already been set up or used in promoting the further development of cooperation for the law practitioners within the region. Some of the mediators have already participated in the solving global disputes, or as well as domestic or local disputes. Not only shall we understand the international legal rules, but also the local rules, so that we can integrate better with the world. We need to consider our uniqueness, the advantages that we set. Macau is a great example. We have the three identities. So we have the we have the three uniqueness in this region. We need to shift our solar solid economy from the gambling industry into other industries, so that we can participate better in the commerce. After discussions, we believe that Macau can contribute in these following 3 points. The first one is to nurture legal talents cross borders. We have set up this goal and prioritized the cultivation of local legal talents as its primary objective. We have done multiple activities and events in order to achieve this goal. Faced with the historical opportunities presented by the development of the Greater Bay Area and Hengqin in-depth cooperation zone, we have actually set up courses like Chinese law and global legal studies, these kind of courses, in order to multilingual legal professionals for Macau, SAR, and the nation.
And second, we think going forward, we could strengthen the Portuguese-speaking countries' legal research services. Recently, the Supreme People's Court and the University of Macau jointly established the China Portuguese-speaking countries Judicial and Legal Research Center. This platform elevated the cooperation between the two regions' judicial authority to a higher level of Sino-Portuguese collaboration. That's second, to align with international standards. That's also where we think Macau can play a leading role. And lastly, in the future, Macau could be established as a one-stop Sino-Portuguese commercial dispute resolution center in terms of legal consultation, dispute resolution, arbitration recognition, and enforcement. That's what we mean by a one-stop services to enhance our Belt Road initiatives. That's a brief sharing. Thank you. Thank you, Dr. Lee. Due to time restraint, that's come to the second session. Originally, I had a bunch of questions, but now I think there's no time for my questions. I'll leave the opportunity to our audiences. And by the way, today you asked me to be here as a moderator, not as a speaker, because I think I could speak a lot. If I work as a speaker, there won't be enough time for mock court. So first question about the service agent and practitioner related. I'm also a mainland China lawyer. So first is to Mr. Lawson Chen in terms of risk agent, because in mainland China it's allowed with the contingency. For example, our clients had a case in mainland China. They asked the lawyer, if you cannot win the lawsuit, then I won't pay you the fee. Is it allowed, or is there any restrictions? Thank you so much for the question in terms of contingency fee. I would say this is a characteristic of China, different from the U.S. or other. It's quite similar to to U.S. and other jurisdictions. But when it comes to civil administration, labor, or other broader civil-related cases, in mainland China, we don't allow contingency fee. However, in the broader civil law area, I think we could encourage this. But there's also restrictions. For example, the standard and also the limit cannot exceed a certain limit, a certain amount. For lawyers, it brings advantages, that is to encourage lawyers to more efficiently do the case. It's not saying if it's not successful, we won't charge. Success or not is not what matters. It's more about the services. If the legal service meets the client's expectation, I think that is the criteria, the more reasonable standard. So based on a certain amount of fee and adding some reward fee, I think that would be more appropriate to explain contingency fee. I'd like to add up a bit to promote Hong Kong legal system. Traditionally, we don't allow contingency fee. That is the basis for common law. That is to avoid the lawyer's personal decision. But in order to complement the world standard or demand last year, only for arbitration, we launched a fee structure based on arbitration result. Just as Mr. Chen mentioned, no success, no fee. Actually, we need to redefine what is success. I won't delve into this, but DOJ has a Q&A session and Q&A leaflet. If you're interested, you can go take one. Hong Kong's arbitration allows contingency fee. That is a large breakthrough, and we welcome you to use arbitration. Thank you. Originally, I had a task that is to promote DOJ, but now thank you so much, Mr. Liu, for doing my job. And now when it comes to Macau, also I'm interested, because for me, I spend most of the time in mainland China and Hong Kong. Macau is something quite new to me. So in Macau, lawyers are also divided into barrister and solicitor. So what is the split of work between barrister and solicitors in Macau? Okay, thank you. So our lawyer friends, we will all address them as barrister or big lawyer. However, according to the Law Society in Macau, we only have lawyer and solicitor. And you need to have the training, the certification to become lawyer. So we only have lawyer versus trainee lawyer. So barrister is more like an oral way of addressing them. Because like in Macau, I saw some law firm, they address their own lawyers as barrister. Yeah, so it's different from what we have here in Hong Kong. So in Hong Kong, it will be deemed as illegal if you call yourself a barrister, whereas in fact you are only a solicitor. Yeah, so when it comes to the three regions legal practice, that are the common questions that we will always encounter. I only have 30 seconds left, and I would like to appeal to the audience. So just now we talked so much about GBA lawyers. For me, I am a Hong Kong and Macau citizen, and in 2003, when we had CIPA, that allowed Hong Kong and Macau citizens to join mainland China's law test, the law exam. So I was labeled as a mainland China lawyer at that time. It's quite different from what we have now as a GBA lawyer. So you can see from the policies and system improvement, you'll see we have better and more sound system. It's pretty much to the end of the discussion here. I'll hand over the floor to the MC. Thank you. Thank you, lawyers. Please stay on the stage for a photo first. One step ahead, please. Front and center of the stage. Thank you. Please be seated. A big round of applause for your sharing. Thank you so much. Next session will start at 10:45. So now it's a break time. Please enjoy the refreshment and coffee outside. And remember to bring along your valuables with you. And for online participants, please stay online. And now, you are more than welcome to visit the booth outside. The next session will be conducted in Cantonese. So if you need headsets, please raise your hands. Our staff will come to you. Thank you.
来宾，我们的
Dear guests, our session will begin soon. Please be seated.
to start, so please take a seat.
Dear guests, the event will begin soon. Please take a seat.
Few minutes. 女士们、先生。
Ladies and gentlemen, the next session is the exchange of legal procedures among Guangdong, Hong Kong, and Macau. Today, we're happy to gather leader figures in the legal council of the three places to demonstrate how to connect different rules and mechanisms through a civil and commercial case so as to achieve soft connectivity in legal and dispute resolution in the GBA. So Hong Kong and Macau will speak Cantonese today, and you can also switch to English channel, channel 1, or Cantonese channel, channel 2, Mandarin channel, channel 3. Today, we are very happy to have Mr. Richard Call SC from Temple Chambers, and also Mr. Max Wu, Secretary General of the Cross-Border Investment Committee of Guangdong Lawyers Association, partner of Guangdong Dacheng Law Firm, and Ms. Oriana Anasia Poon, lawyer and partner, PCC. They will become our judge for the mock court. And for the legal team, our Hong Kong rep is Mr. Matthew Chen and Mr. Ronald Sum, JP. And from Guangdong, we will have Mr. Kevin Zhang and Mr. Junis Xu. And from Macau, we have Mr. Lin Wah Ki Liu and Mr. Chen Wah Chit. Without further ado, the mock court will begin immediately, and now it's time to have a narrator first. Distinguished guests, welcome to the mock court. During this session, we will have a mock case when it comes to trading and payment. After this, I hope you could have a better understanding in the differences and commonalities in the three regions under this very special mechanism. So I'd like to introduce a case a bit. It's related to two cases and three parties. Xiangwen Company is actually a stationery company registered in Hong Kong. Shenyue is the mainland supplier to Xiangwen registered in mainland China. In 2020 June, they signed a buy and purchase agreement. It says like by end of December 2020, they need to pay 5 million RMB to Yuesheng Company. And by the same time, Yuesheng needs to provide stationery to Xiangwen Company. And now Xiangwen paid 5 million RMB to Yuesheng. However, Yuesheng couldn't provide the goods by them. So Xiangwen Company had a an agreement with Aoshen and also Aofeng, who is a sole shareholder of Yuesheng Company. So it's related to Xiangwen Company as a buyer and Yuesheng Company as a seller. Guarantee is Aofeng Company, and the interest rate is 39%. The return date is April the 1st, 2023, and there's no applicable law being stated. So far, Yuesheng Company has not repaid any principal or interest. Xiangwen Company filed a lawsuit against Yuesheng and Aofeng Company in relation to the repayment agreement to cover the arrears and interest. So we have representatives from Hong Kong, Macau, and Guangdong here on the stage. Before Hong Kong party's demonstration, I'd like to see, pursuant to order rules of the High Court of Hong Kong, the plaintiff served writs on 2 defendants in the PRC and Macau outside the jurisdiction of Hong Kong with the leave of the court. Although the 2 defendants in this case are entitled to apply to the court for the permission to be set aside, however, this presentation assumed that the 2 defendants did not file an application for annulment, and the case commenced in the Hong Kong courts in accordance with normal procedures. And now let's have the Hong Kong rep.
亦即係本案被告人律師。
Now let's invite the applicant and the defendant's lawyers representative. Your Honor, I, on behalf of the 2 applicants that are the 2 defendants of this case, to suspend the Hong Kong legal proceedings over this case. A few days ago, I've submitted related documents to the court, and have you read this document? I've read it, and thank you, Your Honor. Now, before I present my case, allow me to briefly introduce the case of this, the background of this case and my application. Hong Kong Company is registered in company. The 2 defendants, Yuesheng and Aofeng companies, are respectively registered in mainland and Macau. The defendants and plaintiff enter into a sales and purchase agreement in 2022. The plaintiffs wanted to purchase some goods from the defendant, and according to the agreement, 500 million have been paid to the defendant, and there was a separate agreement. In January 2023, a repayment agreement was entered into, and the goods were not required to be delivered, but according to the repayment agreement, the 5 million needs to be repaid to the plaintiff at an annual interest rate of 39%. The second defendant, as the sole shareholder of the first defendant, which is Aofeng Company, under the repayment agreement, on that repayment date, regarding this application, applied to the court actually to challenge Hong Kong's court's jurisdiction. Now, regarding this application, in this case, in the SPH, in a 2014 case, in HKCFAR, pages 364, in that judgment, I've also submitted to Your Honor. Do you need me to briefly take you through the previous case? That won't be necessary regarding that case. And let me share with you my understanding. Now, as your applicant, the burden of proof is on you. You have to prove that Hong Kong is not a naturally appropriate place for the proceedings, and you have to also prove that there's another jurisdiction that is a better candidate as a place for the legal proceedings than Hong Kong. I agree. As in the SPH case, that's totally consistent. If you can prove these 2 points, and the other party can also prove and showing if in another jurisdiction than Hong Kong, if that legal proceedings are going to strip them of their individual jurisdiction advantages, and they can apply to the court to take these factors into consideration, right? I agree, Your Honor. Please proceed. Now, regarding the legal views, I would like to examine the meaning of appropriate, by which I mean there is a solid connection between that place of legal proceedings and the case. When deciding on this factor, a lot of factors will need to be considered. Applicable terms is one area, but in this case, relevant agreements did not specify what the applicable laws are and what the applicable jurisdiction is. Other factors like the business and assets of the debtors, the place of the receiving account, and whether the debt will be used in the same places. Those will be factors to be considered. Though the witness's location should be one factor, but given the geographical proximity, that weighting should be limited. Of course, when considering the appropriateness of the place, what matters is not the number of the factors, but one should take a macro view to decide which place is a better location for the legal proceedings. Factors below have to suggest that the place that can establish a solid, meaningful connection with the case. So, as given that relevant agreements were not signed in Hong Kong, so mainland should be the appropriate location, and that the assets and the business of the defendant are located on the mainland, and they have no assets in Hong Kong for the plaintiff to enforce the ruling. And there is no proof suggesting the second defendant, other than holding the shares of the first defendant, have no other assets. Well, in this case, the assets of the first defendant will be the only assets for the plaintiff to enforce the ruling. And the subject of the case, which is the amount of payment, was made in RMB, and that loan has such a background as the goods concerned were under a transaction on the mainland, and all these factors point to the conclusion that, or suggestion, that this case has a solid link with the mainland China. The factors you have just outlined, in general, if we apply them to consider applicable jurisdiction, they have established a fair connection. But that, is it necessarily related to the consideration of jurisdiction? Oh, yes. But you know, this relevant agreement was not signed in Hong Kong, and that's a critical factor. According to according to the White Book of Hong Kong, of the civil lawsuits in Cap 176, Hong Kong companies can be sued in Hong Kong, but defendants outside of Hong Kong should be sued in their place of registration or incorporation. And the only Hong Kong factor in this case is that the plaintiff being a Hong Kong registered company, but as in paragraph 11(1) and 8 is when the court considers these factors, the court should not place too much emphasis on the place of registration, not even giving it excessive weighting, because the place of incorporation has no direct links with where the case should be solved. This single factor is insufficient to overthrow other factors pointing to the mainland China as the appropriate jurisdiction or place of proceedings. For example, in some international disputes, say in the maritime arena, there could be more than one appropriate place of legal proceedings because no single place is a better candidate than the others. But this case certainly doesn't belong to this category. As I analyzed previously, all factors would point to mainland as being a plainly more appropriate place of legal proceedings. The only Hong Kong factor or connection is that the plaintiff is a company incorporated in Hong Kong. So I would conclude that Hong Kong is not as appropriate as the mainland, as the main place of these legal proceedings. And having established that, the plaintiff has to prove that if the case is decided outside in Hong Kong, its own advantages will be stripped according to SPH versus A1. If the plaintiff can establish this point, then the court will have to decide the pros and cons for the plaintiff using mainland as a place of proceedings. If a substantial justice can be arrived at, if the case is decided in the mainland, and that would not deny the suspension application of my two defendants, even though in the said case, in the above context, it only said it would not necessarily lead to failure of the suspension application, but according to the relevant paragraphs in the Hong Kong White Book, in the practice, the burden of proof on the plaintiff. We'll see a more detailed explanation there. And in the White Book, it would say if plaintiffs see some of their individual jurisdictional or judicial advantages to be stripped, it doesn't mean that the suspension application should be denied. Only when the plaintiff can prove that if the case is to be decided in the mainland, a substantial justice cannot be arrived at, will the court accept the failure of the suspension application. But that is not a criteria to be satisfied easily, because those advantages will point to more time and more to be paid to the plaintiff, but these factors are not sufficient. In that case, there are not sufficient facts to show the legal proceedings in the mainland China cannot arrive at the substantial justice for the plaintiff. So you're suggesting if the plaintiff can show that, if the plaintiff can show that there is a chance that some of his legal or lawful judicial advantages are to be stripped if the case is to be decided outside Hong Kong. You said this is the only one of the factors to be decided by the court, right? I agree. Based on the previous reasons, I would apply that you grant the application to suspend the case. Your Honor, I represent the plaintiff in this case. The applicant's lawyer cited the case. He outlined some principle and which we agreed to, and there is one question to decide on. Are there any other jurisdictions appropriate for these legal proceedings? To answer that question, those applying for the lawsuit must establish that Hong Kong is not naturally a locality of a lawsuit without any substantial or real links to this case, or they have to prove that there is a more appropriate locality of lawsuit in Hong Kong. If these 2 points fail to be established, the application will fail. Even the applicants can establish the 2 points, and the plaintiff can show that if the case is to be decided outside Hong Kong, their own advantages are to be stripped. Then the court will weigh between the pros and cons for the plaintiff.
The reasons raised by the plaintiff, including the assets, company, and the place of registration, is all in Hong Kong. Actually, those factors are not sufficient to prove that Hong Kong is not the rightful locality of a lawsuit. And it does not support that mainland is the appropriate locality of a lawsuit. In fact, the Supreme Court case also stated that a similar case of Spiliada, there is a consideration about the connection, about the applicable laws, about the locality of the plaintiff and the defendant. If we consider the connection between the companies, actually it is a breach of agreement, and it is a litigation about the damage compensation among 3 companies. Since the business of the Hong Kong company, which means the plaintiff's business, it's based in Hong Kong, so it is highly related to Hong Kong, and in fact our court is more equitable as a locality of lawsuit in this case, and the court in mainland is only another option, just an alternative to handle this case. There is a case about secondary school in Guangzhou, and the litigation also involved the 3 jurisdictions. In the final statement of the judge, in fact, it takes less than 3 hours to take the train to travel from Guangzhou to Hong Kong, and we even have the high-speed express train now. And we don't need to scan the QR code anymore for the health condition. If the relevant compensation regulations are established in the agreement, then we can apply the conditions in the final result. But such conditions are not specified in agreement. Even if the applicable law is not Hong Kong law, it doesn't affect the proceedings conducted by the Hong Kong court in this case. In fact, the Hong Kong court already has very rich experience in handling cases under laws other than Hong Kong law. When we speak about the place of the place of agreement signage, it is only one of the considerations, but not critical. If we consider the applicable law, we have to think about which place is the most relevant in this case. We have to think about where the agreement is signed, where it is enforced. And we have to determine the responsibility of compensation. If the money is to be paid to the plaintiff, then the plaintiff whose business is in Hong Kong, then of course Hong Kong is a highly relevant place of this case. The civil and commercial litigation in Hong Kong the litigation results can actually be enforced in mainland China. So it doesn't rule out that Hong Kong court is a more applicable locality of lawsuit than mainland China. Do you mean that the location of the assets of both parties should be also considered as factors that would affect where the appropriate locality of lawsuit? But it is not a critical factor. Do you mean that? Yes. It is a very typical cross-border litigation that involves 3 jurisdictions. Hong Kong as an international litigation and arbitration center, it is absolutely the best choice of the place to handle this case. And the Hong Kong court has countless experiences in handling this kind of cases. Putonghua, Cantonese, English, and Portuguese are used in all jurisdictions. And Hong Kong court usually use Cantonese and English as the languages used in the court. However, we also have many cases that employ Mandarin in the proceedings, and we also have very professional interpreters. We can offer simultaneous interpreting service in the courts. So I believe that Hong Kong court is the best place to proceed this case. And Hong Kong as the largest offshore RMB exchange center, if the compensation is to be paid in RMB, Hong Kong is a very appropriate and proper location for this lawsuit. So there is no reason to rule out that Hong Kong as our natural and appropriate locality of a lawsuit. And there is no other places that is more uniquely proper for this legal case. So you mean even if the plaintiff can prove that there are some factors that involve Hong Kong, mainland China, but if they cannot take the burden of proof that the court in mainland China is more appropriate to handle this case, even if the plaintiff can prove the points, which we do not believe those are the cases, however, we have to also balance whether the legal rights and personal rights are stripped away. In fact, in Hong Kong, the court can support or adjust the 30 over 30% yearly interest rate and demonstrate how justice is represented. And moving the locality of lawsuit to another place would strip away the personal and legal rights of the plaintiff and also the defendants. So we would like to make a statement that we would like to overrule the suspension request of taking Hong Kong as a locality of lawsuit.
唯一的
Thank you, Hong Kong law team. And now let's welcome the next Canton lawyer to continue with the demonstration. Let's listen to the Guangdong Mock Court. Let's invite Guangdong's team, please. Okay, court. Now I'd like to verify your ID first. Please, two parties, let us know your ID. Start with the plaintiff. Plaintiff is Xiangfang, and then we hired this law firm to represent us. And defendant, we hire Guangdong Jingqiao law firm Xu Jun. The duration is special authority. So any disputes in terms of identity? No. So now start with the law first. We should adhere to the court rules and orders, no noises. When you would like to make any statement, you need to raise your hand, and after approval, can you say it? And no photography, video is allowed. You cannot raise questions without approval or applaud a big round of applause without approval. Any observers, they should switch their mobile phones to silent mode or turn off their mobile phone. Are you aware of these rules? Yes. Guangdong Yuexiu District Court will start the court. And me, Wu Xiying, is the sole judge. Zhang San is the secretary. Do you need any people to avoid from the court? No. So start with your statement, please. Start with plaintiff. Thank you, Judge. For plaintiff, first, we hope the defendant 1, Yue Shen, could pay back Xiangwen Company 5 million RMB together with interest. The interest rate will be capped at 39% per annum. And since December the 1st, 2022, to 2023, December the 1st. So we have around 2 million RMB as the annual interest rate. And we hope the Yueshen Company, Aofeng Company, will also shoulder the responsibility. 3, the two defendants must afford the litigation fees, including but not limited to translation, court fee, lawyer fee, etc. Reasons being, Xiangwen Company is a registered stationery company based in Hong Kong. Yueshen is a mainland China registered stationery supplier. Defendant 2, Aofeng, is a Macau registered limited company. It is also the sole shareholder for Yueshen. In 2020, Yueshen as a seller, Xiangwen as a buyer. They say the plaintiff will buy 5 million worth of goods from Yue Shen. And by 2022 December, Yue Wensha pay the principal to Yue Shen, and at the same time, Yue Shen should deliver the goods. However, when the plaintiff paid the 5 million yuan to the defendant didn't deliver any good. Thus, plaintiff required the refund from Yue Shen, but was rejected. So the plaintiff signed a repayment agreement with defendant 1 and 2 and saying by April the 1st, 2023, defendant 1 should pay back 5 million principal together with 39% of annum interest rate. Defendant 2 as a guarantee, they also signed on the agreement. However, defendant 1 haven't paid back the money yet. So as a guarantor, defendant 2 should also hold accountable for this. And for limited company shareholder, if they cannot prove their assets separate from the company's asset, they should also hold liability. So as a person, also the shareholder, defendant 2 shall also pay responsibility attached to this. Thank you. Defendant 1 and 2 have already submitted their written statement ahead of the court. Please do a summary now. Defendant 1, we agree to pay back the principal, but we don't agree to pay the interest rate at 39% per annum, and the starting of the annual rate should be 2023 April the 1st, shouldn't be December the 1st, 2022. Our advisors, defendant 2, it doesn't have any responsibility attached to this case. We have already submitted our defense in written form before the court. Thank you. Now let's do the investigation. Before the court, there's a meeting. The court organized the two parties' cross-examination in terms of evidence. For the evidence submitted, the court won't repeat. So for both parties, do you have additional evidence to be submitted? Plaintiff, yes, we do have an additional evidence because earlier the plaintiff submitted the WeChat history. Before the court, the plaintiff submitted the lawyer's investigate notice. We'd like to ask the WeChat operator Cai Fu Tong sign an agreement to give consent to lawyers' investigation. And after investigation, we'd like to submit the evidence number 9. It is the Cai Fu Tong payment platform. They issued a document to assist with the investigation. So WeChat ID ABCD's real name is Li Si. ID is 1234. That is the plaintiff, one of the sales agent of plaintiff. Thank you. So for the additional evidence, do you have any opinion? Thank you. So for this evidence, the authenticity and validity and legality are still need to be verified. It could only say the WeChat ID's entity and their ID. Just as what we mentioned before, we have said the plaintiff provided by the WeChat history provided by the plaintiff is fragmented. It cannot fully give us a picture of the communication regarding the repayment agreement signature. And in terms of the repayment terms and conditions covering the payment date, etc. So the WeChat ID itself cannot prove the repayment agreement's clause. Thank you. So if the plaintiff has any response to the defendant, you can wait till later at the rebuttal. Now the court will regard the facts to raise several questions to both parties. Please answer honestly. Question 1. This case, shall we use mainland China or Hong Kong law or special or Macau law? Plaintiff, please. I think the purchase agreement place and also the payment date is Guangzhou. Guangzhou is a place where the transaction took place. The repayment agreement is a follow-up agreement pursuant to purchase law. We should take mainland China law. Thank you. I think the core conflict is the repayment terms, and in the agreement, the entity defendant 1, we should use the law in where defendant 1 is based, that is mainland China. And defendant 1 also agree we should use mainland China law. So according to your advice, both parties think we shall use mainland China law. There's no dispute here. Second question, do you confirm the repayment terms are regarding the principal and interest rate? Signed, your advice, please. I think the repayment term is not a borrow and lending agreement, but it's an additional agreement in addition to the purchase agreement. That is to add up to the payment terms. It didn't use any borrow or lending terms, but it's saying it's an additional term under the original purchase agreement. So in this new agreement, the purchase agreement, there's no terms related to the payment. So we regard it as an additional one to the original agreement. I don't agree with the plaintiff's idea. We think in the repurchase agreement, plaintiff and defendant's ideas are clear. So two parties would like to turn the purchase into a borrow and lending relationship. They will forego and let go of the original repurchase agreement. They establish lending and guarantee new terms. So the lend and borrow relationship is clear. Thank you. According to both parties' opinions, we have a different understanding on the nature of the agreement. Third question, in 2023, before November 2023, did the plaintiff ask the defendant 2 to repay the money? No. Confirmed. Defendant 2 never received plaintiff's claim to repay the money. So for both parties, at this stage, do you need to state anything? No addition. No either. So the court investigation ends here. In conclusion, the focus disputes are as follows. First is a repayment agreement, whether it is an additional agreement to purchase agreement or this is a separate borrow-lend agreement. Second, for the borrow-lend agreement, the interest rate here, shall we take it as a civil law limit cap? Shall we adjust according to that? And defendant 2, our phone company, shall it take responsibility to plaintiff 1? So for these three focus points, do you agree or do you have any additional? Plaintiff has no idea, no either from defendant. So now let's come to the rebuttal session. Please, around what I just said, concluded, please start your debate. What is your opinion and fact? I think this case doesn't belong to borrow and lend agreement, and it won't be subject to the cap limit. So we shall pay it back at the rate of 39% per annum. Second, defendant 2 as a guarantor should hold liable even if we forgo of its guarantor role. As the sole shareholder of debtor Yue Sheng, we cannot say they have separate assets. The guarantor should also pay the responsibility. So please, defendants, please start your defense. Two defendants will issue the opinion separately. First, Yue Shen and Xiang Wen signed the purchase agreement has already been replaced by the borrow land agreement. The trade relationship has been untied, and through signing the repayment agreement, a new land and borrow relationship was being built. Second, Yue Shen Company's relationship with Xiang Wen should use mainland China law. According to Supreme Court's civil borrow and lending rules, clause 25. If the lender asks the borrower to pay the interest rate, it should be at 4 times. And actually, it was established in December 2022 at that time. The loan market rate is 3.65%. Times 4, it's around 15 something. But the 39% annual interest rate is far exceeding with China's civil borrow lending rate. So we shall use a civil lending cap that is 15%. And defendant 2, we think when signing the repayment agreement, we didn't hold a shareholder meeting according to company's AOA Article 16. When investing or providing guarantee to another company according to Article of Association, they should be approved by the board of directors. That's how the Alfong, when it made the guarantee, it was against and neglected the company law, so it should be deemed as invalid. And in the repayment agreement, there's no duration being listed. According to civil law, during the guarantee period, so that is 6 months since the payment date, it should be paid by April 2023. Just now, the plaintiff said before that, it didn't raise to the plaintiff about its plea regarding repayment. So Alfong's guarantee responsibility already expired in December 2022. According to the civil code, the defendant 2 has no need to pay back or have any accountability to Xiangwen Company. And according to the sole shareholder of Alfong being in Yuefeng, it is groundless because the clause that you mentioned, it only applies to the circumstances when Alfong is tied up with Aumen. In fact, Yue Shen is in mainland China, Alfong in Macau, and they have separate registered capital and structure. They operated separately as well. That's why defendant 2 has no liability to defendant 1's case. Thank you. So for your advice, plaintiff, do you have any reaction? Yes, I'd like to respond. First, repayment terms only said plaintiff 1 should pay back 5 million and interest rate. However, for 5 million principal, it's actually plaintiff 1 paid defendant 1 based on the purchase agreement. It's not a borrow and lend agreement. So from the very start till now, the plaintiff didn't imply any borrow or lend relationship to defendant 1. Second, defendant 1 didn't send any good when it should be and didn't pay back when it should be. And the interest rate written here, defendant 1 is aware of that. So it should pay the interest rate according to the agreement. Third, defendant 2 as a guarantor is signed in the agreement, then it should act as a role of guarantor, even if without the consensus or board resolution. That is your internal issue. It shouldn't affect plaintiff. Fourth, according to Supreme Court's rule in terms of civil code, its interpretation is saying its company or subsidiary provide guarantee. The mother company or the sole shareholder should guarant defendant 2 as the guarantor of defendant 1. Once it provided guarantee, then it should fulfill its responsibility. And also whether defendant 1 and 2 are separate. It's not based on different registration places. It needs proof of evidence. If you cannot prove evidence by a certain period of time, then it will be deemed as failed to provide evidence. So court, please consider them as not dependent. So any additional points to add? Yes, I have. Regarding plaintiff and defendant's relationship, if you don't think this as borrow and lend, then when it comes to two parties, the 39% annual interest rate is too high and much higher than the actual cost that may or have already occurred to the plaintiff. So according to the law, the damage is higher than the actual losses. The court should act or decrease the interest rate. The court used mainland China law, so the defendant pleads that when it comes to the decision, you shall cut down the interest rate. Thank you. So this is the end of the court opinion. Let's come to the closing. Plaintiff, please summarize or do any necessary addition, please. Thank you, Judge. So the evidence provided by plaintiff has a very full chain of evidence. It shows plaintiff 1 is against the agreement, didn't deliver the goods, and it also didn't fulfill the agreement, so it shall hold accountability to pay back the principal and also annual interest rate. The evidence is sufficient, and I hope the judge could support us. Thank you. Defendant, please. Defendant 1 agreed to pay back the principal, but we don't agree on the annual interest rate, which is higher than the limit stipulated as China law. Second, even if this law is not considered as borrow and lend, the interest rate is much higher than the loss actually incurred to plaintiff. That's why we asked to lower the interest rate. To sum up, if plaintiff regard this as the promise or guarantee term, this guarantee is against the company law. And also the plaintiff didn't claim its right under the civil code. So defendant 2 doesn't need to shoulder any responsibility to plaintiff. Defendant 2 is the sole shareholder of defendant 1 and thus need to carry responsibility as well. But what we see is these two entities are separate and they don't have, defendant 2 doesn't need to be engaged. Please rebuttal or reject their claim. Thank you. Thank you for your opinions and facts. Because the agents give you the exclusive rights and authority, so both parties are able to take authority. So each party, are you willing to do a mediation? Plaintiff agrees. But we currently don't have a mediation solution. We need to go back to communicate with our client and come back. yes, agree to mediation, and also we need to discuss with our clients. Considering both parties have the willing to mediation, I'll give you 10 days to have an initial discussion and negotiation. We hope to reach a mediation. So in any time within the next 10 days, if you need any mediation from me, please contact our judge or the secretary for arrangement. That's the end of today. Please read the recordings and then sign on it. Thank you. The end. Thank you for the team from Guangdong. And now let's have another region, Macau, and then to see their case. So now is the Macau Mock Court. Give them a big round of applause.
All who should be present have been notified and attended. Now the hearing will begin. This case is an action for payment under ordinary litigation procedures. The plaintiff is Xiangwen Company, and the defendants are Yuesheng Company and Aofeng Company. The plaintiff requests a compensation from the defendant of RMB 5 million with interest. The court has already issued an instruction of clearance and handled some prerequisite questions, including the jurisdiction question. Although this case involved different companies in different regions, however, one of the defendants is Macau company. Therefore, there is a right of jurisdiction in Macau, and there is no invalid questions in this case. The related parties have their own rights and reasons. There are no other prerequisite questions to be tackled in the clearance in the clearing instruction. The confirmed facts are already clearly presented to both parties. The relevant facts of these rebuts are the following. There are two facts regarding these disputes, and both parties have no objection towards the clearing instructions. The issues in this case can be penalized, and the discourse will try to mediate between both parties. There are two critical points regarding this case: whether the debt is cleared and the interest is paid, and the other point is whether the interest amount is appropriate. Representatives of both parties, is there any opportunity or chance of mediation in this case? Your Honor, we could not reach a favorable result in mediation because we have large disputes in terms of the amount of compensation. Since mediation cannot resolve the case, thus we will enter the stage of statement. Now we will enter the hearing section. Now we will hear the statement from the plaintiff. The witnesses of the plaintiff side have to take an oath. What are the questions to be asked? I would like to ask the witness about the two facts, regarding two facts in this dispute. I finished my questions. Any supplementary questions? No. We have already listened to the witness of the plaintiff. Now we will listen to the witness of the defendant. What would you like to ask the witness? I have finished my questions. Thank you. Plaintiff, any supplementary questions? Yes. I have the following supplementary questions. The hearing has been complete. And now we would discuss about the facts regarding this dispute. Each party can object the statement one time of the opposite side. I am the litigation agent of the plaintiff. All the facts stated in this case by the plaintiff are already proven. And all the statements raised by the defendant could not be proven, including the disputes regarding the signage of agreement. The evidence clearly proves that the place of agreement signage is in Hong Kong. Because the place of signage is in Hong Kong, and the plaintiff is also a Hong Kong company. Therefore, we believe the agreement should comply with the Hong Kong law. And it is proven that the defendant has not paid the debt, that is including the interest. The defendant only paid other debts than the debts in concern in this case. These facts are already proven in this hearing section. To conclude, based on the witness statement and the evidence presented in this court, the claims that the defendant made about that they have already paid the interest and the debt are already rejected by the plaintiff. The defendant refused to therefore we request to record that the defendant should pay all the debt, including the 39% of the interest. Or perhaps 39 could be regarded as a very high interest rate. However, because this case is related to a commercial practice, and there is and interest rate is calculated based on the commercial laws of the plaintiff. And the guarantor of defendant 1 is the sole owner of defendant 1. Therefore, we request the defendant pay the whole compensation to the plaintiff. After the hearing, we believe the facts of the dispute are as follows. The agreements are signed in Macau. There is news posted on the website of Xiangwen Company stating that the person in charge visited in stationery exhibition in Macau, and there is proof that the agreement is signed in Macau. And the secretary of Yuesheng Company was responsible for preparing the materials and documents, and she
And during the lunch break, and the repayment agreement was signed. So the agreement could be shown to be signed in Macau. And as for item 2, up until today, November 9, 2023, the Yuesheng Company has already repaid 5 million RMB to the Hengman Company. And this can be seen in the written proof. It is an invoice showing the repayment has been completed. Based on these two facts, our dispute regarding the applicable laws, we have presented the following understanding, because this repayment agreement has never mentioned any applicable laws. According to legal conflicts in Macau, if without the explicit agreement on relevant laws, we should apply the highly relevant laws. And there are 3 locations, mainland Hong Kong and Macau. There are links between the 3, but the 3 companies have chosen Macau as the agreement location. So it can be suggested there is consensus on using Macau as the contract location. So Macau should be seen as the jurisdiction governing the agreements, especially the interest payments. If the interest payment exceeds over 3 times of the statutory rate, that is 29.25%, it is excessive and is a loan that can be revoked. So this excessive amount will not be supported. And based on the second item to be proved, we have proved that Yuesheng Company has repaid the principal of 5 million RMB to the plaintiff. So no other amount is to be repaid to the plaintiff. So, Your Honor, based on our legal opinions, kindly make your decisions. Even if you think interest payment and should adopt a 29.25 interest rate as according to Macau's requirement. Please consider the principal has been paid. The excessive interest amount should be reduced moderately accordingly. Please make your judgment as just as ever. Any counterclaim from the plaintiff? Based on the presentation by the defendant, I should make the following statement. Thank you. The defendant has presented his case. We duly respect, but we disagree. Regarding questions on the contract location, we can see that on the date, there's a ticket of travel from Macau to Hong Kong. It showed that the signatory of the plaintiff, and having attended the Macau's event, had sufficient time to return to Hong Kong to sign the agreement regarding this. And you should have heard from our witness and concluding the lack of credibility of the defendant's case, that our representative was not in Hong Kong, and this was simply not true. And the invoice itself was not questioned in terms of its credibility, but their question is that this invoice should not be the basis for the repayment agreement. But you can see in this screen cap of WeChat conversation, there's the finance people between Xiangwen and Yuesheng companies. The Xiangwen companies did not made a question on the invoice use, but the Yuesheng company did not formally address this concern, considering the long-term business partnership between the companies, and there are frequent transactions between the two. The two companies had more than this sum between them. From this invoice, it did not sufficiently show what the repayment is used for. Only a sum was provided there. So this sum cannot be proved to use to repay the said compensation. So the defendant has never repaid the principal regarding the interest rate, and please consider that this is a commercial loan, and additional 2% is to be added and times the multiples. And please consider our side and arrive at your conclusion. Any supplementary comments from you, from the defendant's side, regarding plaintiff's presentation? We respect, but we disagree. Though they have presented a train ticket, it does not sufficiently prove that the person involved actually returned to Hong Kong physically. There were questions, and our witnesses have shown that the contract was signed at noon, and it is rare that three companies would sign an agreement in Hong Kong at midnight. So this is not to stand. When it comes to the WeChat conversation, it fails to show whether that invoice is used to pay for another batch of goods, and the plaintiff has never stated any other sum required to be paid by the Yuesheng company, and there's been no proof for other transactions. So we cannot conclude that this is a coincidence. Otherwise, the plaintiff should have objected to such inference. So, Your Honor, please grant our application, having made your fair judgment. Now, having concluded this debate and argument, and we are to adjourn to arrive our decision.
感谢。
Thank you very much. Thank you for lawyers from the 3 regional teams to solve the same case, the different methods to solve the problem. So now I have received quite a number of questions. The 3 parties in the different courts, there will be like a different guidelines and principles. The previous cases about the how to utilize the rules and regulations within the local laws. Let me invite first the Hong Kong team to answer this question. The lawyers from the Hong Kong team. Mandarin or English?
審理
Generally, for a Hong Kong court to decide on the case, the legal literature to be considered, of course, include the written law itself. For example, the case involves certain laws or procedures. If we were talking about sales and purchases of goods, and there are relevant laws governing it, and certain cases will also be considered, including domestic cases. And we have a court of final appeal cases, appeal court cases, or the court of first instances cases. Cases of other jurisdictions, say the UK or Australia, will also be considered. Sometimes we consider Canadian cases too. And UK cases are more often considered. If a new legal arenas are to be involved, if there are not sufficient cases in Hong Kong or in the UK, and we'll take reference from cases in Canada and Australia. And these are usually the factors to be considered by Hong Kong courts. In supplementation to Richard's, as the mock court showed just now, Melville said that he quoted one case named Asbiliada. If I remember correctly, it was a British case. I quoted another case, SPH. It was a CFA court in Hong Kong. And in that very case, and that judge quoted Asbiliada. So in the mock court, it demonstrated what Richard said, that a case in overseas jurisdiction, in that case the UK was quoted, and in the case I quoted, in the CFA case I quoted, the judge agreed to take reference from the British jurisdiction case. So cases of different jurisdictions could be referred to. This is what the mock session just now showed.
Let me switch into Mandarin. One of the unique points is that we also will consider different cases or rules or regulations from different places. We have receiver procedure, for example, for civil procedures. So every year, this procedure will be updated. It will amend it according to different cases. So it is very specific book. For us, it is a very professional book. It's a tool, and also a house book is also a common book. For us, it is a very useful tool, which include many cases that are written inside clearly. What about the Macau team and also Macau team?
We can also speak Cantonese, and as Mr. Zhang said, the transportation is very developed now within the Greater Bay Area.
Let me switch into Mandarin. The previous question discussed, I believe, is a good question. Our colleagues that have presented the cases, and actually in our mainland China, we have specific guidelines and rules and history that are written, for example, in the civil law, item 10, they were also written inside. So we shouldn't disobey the society's customs. So this item already reviewed. The laws will consider the public's ethic traditions. So by understanding this particular point, we need to have a more macro view about this point. So as PRC's legal system, we have already set a very systematic rule now. We have the CPRC's set of laws and regulations, including the Supreme Court, the further explanations and interpretations of the laws, including regional regulations, department rules, and regional government rules. All these could be possibly considered or obey during real cases. In practice, we can see from the statistics that the court, the more popular that we're going to use is the laws and also the regulations. The third will be the interpretations. So in the system that I just mentioned, these three will be very popularly used or adopted in real cases. So this is a general view. Another point is, including the cases studies and also the books that will be considered, I'd like to discuss further regarding the cases. Mainland China, especially Hong Kong, it's a civil law system, a common law system. We have different traditions. The underneath basic logic is that where is the law originated? So the civil law should be very practical. The basic law is based on the cases. So mainland China, does it consider the cases useless? I don't think so. Especially during the most recent decades, the Supreme Court pays more and more attention on the different regional courts on the huge amount of cases. We handle similar cases all around different places, whether we should use similar standards to adopt and use laws. And not only shall we conduct the practice in a more freedom way to solve the problems, we shall prevent that we not only has the freedom, but also shall be conducting or practice the law under certain circumstances systematically. So we have the guidelines or guidance from the Supreme Court to handle practical cases. Now we have already achieved quite a mature system. Cases actually are a very critical implementary in our system. The Supreme Court has already passed the procedures to select some of the standard or sample cases for us to take reference. And this involves every sections of a life. And we have the committee's permission and discussion and commission so that we publish afterwards. These cases represents more valuable reference other than other common cases. So if you happen to take cases like these, you'd like to consider to take reference of these cases. The second category is some cases that have unique guiding significance. Like the Supreme Court and the High Court and the Medium Court, they have used multiple channels and methods to publish some sample cases already. So these platforms including, but not some of the public, some references, documents published, cooperating between the Supreme Court and the local courts. Some of the opinions were already published. So we would like to take in consideration of these guidelines and also the cases and the standards. It's just that it's not that strong as the Hong Kong system using the cases. The Supreme Court, during the judgment, the judge will sometimes see that certain cases are actually used in practical law practice over the country. Our capability and education background is much more improved. So the exhibitions has been further developed, but we need to differentiate between whether it's a mandatory practice or unified form. So thank you very much. Let's invite the Macau team. So I've actually learned a lot from the sharings from the two teams. For Macau, we have actually had similar situations as the mainland China. So we have some of the previous cases. We can take these references. But in the system, in the civil law, like my colleagues, the two books demonstrating on the stage, so we can use the books to set the rules, laws clearly. And then we have 5 different courts, different books. So this is the laws that we have. About the cases, though, so we are not based on the basis laws. So, however, in the judging different cases, different courts, the court will take reference of the cases that have already been settled by other courts. And it's quite commonly used in Macau. However, it's not as mandatory in Macau. It doesn't enforce everyone to use this. But we would have, however, we hope to reach general consensus regarding this issue. The common consensus in some cases will be published, making sure all the courts will obey this consensus or explanations or interpretations. So our cases actually are categorized at different levels. So our experts or legal practitioners should get familiar with these regulations. Regarding the cases, there's also another side I'd like to mention. In local cases, we would like to use the reference of Portuguese cases. Maybe this because that we have highly influenced by the culture, and also would like to refer some of the Portuguese theories, such as the rights protection, which were published already by mainland Chinese researchers or scholars. So this represents some of the guidelines for us to first to use. Thank you. About the theory, I have further point to add. Actually, we are originated from the Portuguese laws, which has developed over centuries. So we're going to use really some classical cases to set as reference. We won't use some common cases, but we're going to use those so-called classical that sort of authorized the cases, to use such cases to guide our real practices. So some professors from universities will also refer to their opinions and theories. Thank you. Another question is, with the development of GBA, stepping into the global market. How Hong Kong and Macau should cooperate with the mainland China in areas such as make it more clarified in setting up the law systems. So can we invite Macau team to answer this? As a matter of fact, in Macau, if the court or the lawyers need international laws, we would, as lawyers, ask the foreign lawyers to provide some basic regulations, and our court will examine it by ourselves. So in general, we would examine this ourselves. The lawyer will present, and then the court will examine it and to see which case, how to better use this. But we don't have a written system in this. Let me add one point. According to Mr. Pan, I do agree with Mrs. Pan's comment. So we don't have very rigid or very or detailed center or explanation or interpretation centers to explain this. In Greater Bay Area, we have one country, two systems, and three policies. So we have the current modern law systems. We have Hong Kong and Macau systems, and also we are deeply influenced by the European system. We have basically covered all the major law systems in the globe. So we have considered already other law services provided by other lawyers in other countries. The system that we are trying to build in Greater Bay Area, there could be one thing quite unique that we have lawyers coming from Macau, Hong Kong, and mainland China, lawyers working all together in one law firm. So that's quite unique. So we're going to use three of the systems. We can use different methods, trying to work out a better solution, case by case, in order to, and we hope that we can further make better interpretation of the laws. And this job is quite meaningful. Thank you. Thank you, Macau team. And Hong Kong team, please.
How can we cooperate? Allow me to raise an example. I used this more than one occasion. If you have visited any charge hunting Hong Kong style restaurant, have you been any of this kind of restaurants? If you want to order milk tea, they will give you milk tea. If you want coffee, they will give you coffee. If you're in a hurry and you want both, they can combine both and give you a mixture. If you want an egg sandwich with a fully cooked egg, they can also give it to you, and that is the characteristic of the Greater Bay Area. As what has been stated by our peers in Macau, the whole Greater Bay Area have very diverse laws, including the European laws, the common laws, and the continental laws. No matter where you are, there are many different lawyers specialized in different jurisdictions. So the Greater Bay Area is just like a charge hunting restaurant. Whichever law you would like to apply or employ, you can find it. Even the Muslim law, the Islamic law, you can find it in here. Every enterprise in the Greater Bay Area can use the legal support within this region. They can receive support of common laws and continental law. And this is exactly the most unique advantage of the Greater Bay Area. Thank you.
如果从
I mean, add one point. From the procedures in Hong Kong court, if we like to test whether we need to use the mainland China's experts to provide their professional opinions, from the procedures, this is part of our test, and this also could be concluded in part of the evidence. So the court needs, for example, the both parties to invite the experts coming from mainland China to present in court, to elaborate verbally, to take the questions raised by the other party, and also to check the actual law regulations written in mainland China. And also Guangdong representatives, we have already discussed that in mainland China, we need to find some relevant law experts to provide law opinions under the Hong Kong laws. And we need to find some experts to provide their professional opinions from mainland China. So we are offering this platform to get involved multiple parties. Most commonly, we're actually looking for the right persons. If you want to find a reliable person, everyone trusts him to be an expert to provide a trustworthy opinion. So we can find such personnel or expert or talent via the platform. Thank you. Just now, you already pointed the differences in procedures between Hong Kong and mainland China. So I have actually written several opinion documents provided to the court, but in Hong Kong, this cannot be done. If you just provide evidence, this is not okay. This is a big difference. Some of the clients from mainland China, they don't understand why your procedures are so long, because every step we need to provide evidence. The evidence cannot speak for themselves. We need people to explain and interpret for them, and we need to judge whether it's true or false. The court will not consider the evidence if it is not testified. This is very critical. Thank you. Let's invite the Guangdong team. Let me elaborate representing our team. Under the Belt and Road Initiative, we have seen many cases globally or locally, and we have cooperate already among different teams. We have already seen that this needs within the region that we need to better cooperate. And over the past few years, we have already achieved that some of the Hong Kong and Macau lawyers have already gotten the certificate provided by mainland China, which is a brilliant thing happening. Now we see a bright future for the region, that lawyers within these regions can cooperate further and deeper with the international law practitioners. We need the support. And we hope that we can cooperate better and more. I hope in the future, in the investments overseas, etc., these areas we can have more cooperations, providing better qualified services in the region. Thank you. Any other points to add? The other two colleagues? Let me add one point. I agree totally. Mr. Xu, Mr. Zheng's speeches, they mentioned the cases that we all experienced in mainland China through some different platforms, supporting platforms and centers. We have connected Hong Kong law experts to get involved in specific cases, providing their own opinions and reports. So the Hong Kong law experts are very professional. and they are willing to come over to mainland China to take the questions from the different parties. They're very elegant and professional. I learned so much from them. And also for me, I also represent on my Hong Kong client to provide my opinions or on interpretations of the mainland Chinese laws. So in real cases, we have already communicated over the years, except for some expert platforms or centers or organizations. I think what we need more is opportunities like today's forum to communicate face-to-face further and better, not to rely solely on the third party. Thank you. Thank you for the 3 teams. Please stand forward to take a group photo. Please, Judge, can you stand in the center? And the lawyers who represent plaintiff, please stand on the left, and the other party, please stand on the right of the judge. We have really enriched our understandings of how the three places are solving the cases in a different way. The plaintiff's lawyers, please stand on the left. The other party representing the defendants, please stand on the right of the judges. So the 3 places, I hope they can really cooperate better and further and deeper. Let's look at the cameraman, please. Can we please step a little bit left forward? Thank you. Thank you very much. Thank you. Please be seated. Dear guests, leaders, and guests online, this morning's session is towards the end. Now we have half an hour for lunch. Please take your valuables together with you, and you're welcome to come back at 2 o'clock this afternoon to participate in the forum this afternoon. The opportunities in Great Bay region area, and those who have colored badges, please gather together on the first floor of this hall to enjoy the luncheon. We have staff to show your way. Thank you.